Section 2.2.3 discusses privacy issues with regards to the search and seizure of computers and phones. The beginning of this section starts with the Supreme Court's ruling over the state of Alabama's request to get the list of members of the NAACP in the 1950s during the Civil Rights Movement. The ruling was privacy in group association may be indispensable to preservation of freedom of association, particularly where a group espouses dissident beliefs. The Supreme Court decision in protecting the information of members was crucial because sharing the information to others would have put the lives of the members in danger. This ruling helped protect people's privacy and helped define what information is personal. In this section, we will discuss how far does the search warrant extend when searching a computer and when a search warrant is needed. In order to figure out how far a search warrant extends, we need to know what exactly a search warrant is. A search warrant is a legal document issued by a court authorizing a police officer or agent to search a specified place for evidence even without an occupant's consent. The Fourth Amendment states the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. This means the search warrants must be specific about the objects of the search or seizure, and only certain bodies can perform a search lawfully without a person's consent. Courts traditionally take the view that if an officer with a warrant sees evidence of another crime in plain view, the officer may seize it and prosecutors may use it. The amount of information that might be in plain sight inside a house or apartment is a lot smaller compared to what's on a computer or phone. For example, a business might have thousands of records that have people's personal information. You can get a lot more information out of a computer than you can just from searching a home or business, which can be a serious threat to privacy. So what constitutes something as being in plain view? When officers are searching for evidence inside a home, they are working within a limited amount of space, but when they are searching for evidence on a computer, it's different. The amount of space is a lot larger, so one interpretation of what might be considered in plain view are files that are not encrypted. Officers might get warrant for a minor offense that might lead them to other crimes like child pornography. The Fourth Amendment will not apply if a person doesn't have a legitimate expectation of privacy. One can argue that if someone didn't have a file or folder encrypted, then they didn't expect that file or folder to be private, assuming that person's computer wasn't locked. Another issue with having files that are encrypted is that the courts have been inconsistent with their decision to require the suspect to give up encryption keys. The Fifth Amendment states that the person cannot be forced to testify against themselves. However, courts have allowed the government to require a person to provide keys or combinations to the safe. This ruling has been consistent on whether or not this applies to encryption keys as well. In an investigation about of the use of performance-enhancing drugs by professional baseball players, lawful enforcement agents obtained a search warrant for computer files of laboratory records on drug tests for 10 specific players. The lab files they seized contain records on hundreds of baseball players, hockey players, and ordinary people who are not athletes. The agents found more than 100 baseball players tested positive for steroid use, but the federal appeals court ruled that the information on all but the original 10 players was not beyond the scope of the search warrant, and the government was wrong to seize it. We have been focusing mostly on PCs and servers as part of the process of searching with a warrant, but in most cases, police officers can search an arrested person without a search warrant, and they can examine the personal property. Many people use their cell phones and laptops for work and for personal use, like taking pictures, storing contacts, emailing, etc. There have been different rulings from different states for saying whether or not the search and seizure of mobile phones is constitutional. For example, the Ohio Supreme Court stated that the type of information that is in cell phones is the kind of information that the Fourth Amendment protects. The point of searching an arrested person is to protect officers from from any weapons that the person may be carrying and to protect evidence from being destroyed. They also ruled it to be unconstitutional for the most part, except for emergencies. But on the other hand, the California Supreme Court ruled against it, saying that phones are technically a part of your personal property and basically fair game for officers to search without a warrant. They also stated that the police have searched cell phones taken from arrested people plenty of times, basically making it okay. When this book was published, the Supreme Court had not made a ruling on whether or not this was unconstitutional. But as of June 2014, the Supreme Court ruled that the police may not search the cell phones of criminal suspects upon arrest without a warrant. According to an article by CNN, criminal suspects in Massachusetts and California were separately convicted in part after phone numbers, text messages, photos, addresses obtained from personal electronic devices linked them to drug and gang activity. Those cases were appealed to High Court, giving an opportunity to re-enter the public debate over the limits of privacy rights, with a focus on ubiquitous cell phones and vast storage of information and video. The appeals were not related to the recent mass surveillance of phone metadata by the NSA, which has raised similar constitutional concerns. The ruling said that that technology now allows individuals to carry such information in his hands does not make the information any less worthy of the protection of the Fourth Amendment. And this concludes section 2.2.3.